Here to talk about litigation after lockdown, we've got Dan Herman from Stewart's in Leeds, Lois Norris, who before she was pupil here at No5 was Gerard McDermott's assistant, and me, Matt Brunning. We've all been forced into adopting a whole number of changes to the way we act. Some of us, I'm sure, are desperate to get back to working in our pre-COVID ways, but rather than merely making a virtue out of necessity, we thought we would have a look at what are the COVID-enforced changes we want to take forward. We're going to talk about 5 areas: face-to-face meetings, expert assessments, costs, budgeting and otherwise, the impact on current claims, and life expectancy form of award. So over to you, Lois.
So the first topic that we're going to have a chat about is face-to-face meetings, which is particularly pertinent, I imagine, for you, Dan. Dan, all of your cases involve claimants with serious injuries, and therefore I would imagine, particularly at the beginning of a claim, that you would be visiting claimants and their families, both in home and at hospital. That obviously can't happen anymore. How have you been adapting to that?
Yeah, thanks. There are a lot of challenges facing us with the new arrangements we're having to make, but I think one of the real difficulties is that initial client meeting. Obviously, it's the clients that we need to speak to first and foremost to get an understanding of the accident, to get an appreciation of their injuries, to make an assessment about whether or not they've got capacity, to make an assessment about what their credibility might be and whether it's a case that we even want to take on in the first place. And even when you can speak to your clients once they're out of ICU, it's difficult via a Zoom meeting or a FaceTime meeting or something similar to create the same experience that you would ordinarily have face-to-face. You're usually looking at someone's head and shoulders in the same way that we're looking at each other now. You can't get a proper appreciation of the whole of the claimant. We'll look at their function, look at their spasm, look at their ability to transfer, and so on and so forth. It's also difficult when you're looking at one person, often on a small phone screen, to get an impression of the family dynamic, which is of crucial importance when you're taking on a new case. And it's also, and this is really important, particularly from the client's perspective, it's more difficult, I think, to build a rapport with a client and their family. It's really, really important. We spend a lot of time explaining things to clients, trying to build up a relationship of trust. And whilst that can still happen, I think it's more difficult when you're dealing with things over video than if you're sat face-to-face with someone.
Definitely. And I think it also depends how comfortable people are. I mean, I talk to the girls, my friends, every day on FaceTime anyway, but when I FaceTime my dad, for example, I only see his chin because it's not something he uses, nor is it something that he feels comfortable with. So I imagine as well, when you're talking about building up rapport, that's also something that's quite important, how comfortable the client feels using technology, because presumably there'll be some people who've never really done that before.
Yeah, that's right. And, using technology in circumstances which are already very trying and very worrying for them, the last thing they want to be doing is seeing the disembodied head and shoulders of a solicitor popping up on a screen in front of them. But, I think a lot that's why some claimants are instructing solicitors later. And one of the other consequences is that because hospitals are trying to discharge patients sooner rather than later so that they're at risk in hospital for a shorter period of time, it makes our job as solicitors all that more difficult because you've got a shorter period of time from instruction to discharge to be putting in place all the arrangements that clients need, whether that be via interim payments or by securing funding under the Rehab Code or Serious Injury Guide.
And I know that you just mentioned then that it's really important trying to assess the claim. Coming into that, and Matt, you'll have experience of this as well, of capacity and credibility. 2 separate issues, but 2 things that fundamentally must be a lot harder to assess when you're doing it remotely.
Yeah, I think that's right. The courts at the moment are trying to get trials up and running in a number of areas, but almost universally they're saying that credibility issues are not suitable to be dealt with by video link, that it doesn't give a judge the capacity to assess in the same way as face-to-face. As counsel, when we have issues of credibility coming up throughout a case, it's never an issue you deal with by telephone conference. And I don't think a video conference is anything more than a patch, a make do amend for now. Ordinarily, those are meetings that will continue to be dealt with, I think, face to face. I think there are other client meetings that we currently do by telephone, where because we're all getting more used to doing using video, my parents now have worked out where to put the iPad so I can see both of them. And sometimes they even seem to have matching tops, so it's a little bit alarming. But for those sort of meetings where previously we would be talking to somebody on the phone and maybe their spouse would be trying to overhear in another room, actually a video or Zoom meeting is a better way to do it. But for the initial meetings, I entirely agree with what Dan says. It's just not a suitable way to do it unless we really have to.
And I think with serious injury claims, most of them do settle before it gets to trial. So one of the main things we deal with are joint settlement meetings. I don't know whether you have any experience of those recently, Dan, but again, I can see some advantages to those in that I can understand that claimants may feel more comfortable being in their own home rather than in a chambers that they've never visited before on a day that's going to be incredibly important to them.
Yeah, I think there are some advantages, bizarrely, with the new arrangements we're having to make and doing JSMs via Zoom or Skype. The one you've just alluded to about clients being in their own homes is definitely one. I had a JSM recently involving a client with a spinal cord injury, and the fact that he was able to go retire to his bed every so often, rest, then come back into his living room or take the iPad to bed and deal with the JSM from bed was much better for him than it would have been had he been in one of our conference rooms, either in his wheelchair or transferring into one of our conference chairs. So there are benefits, but I think there are also disadvantages when it comes to the parties, the individuals who are doing the actual negotiating, which is usually counsel. And I think, Matt, you're probably in a better place to comment on the merits of remote JSMs from the point of view of counsel.
Yeah, I think they are functional at the moment, but they're nowhere near as good as a face-to-face meeting. And I think in all environments, we're looking for non-verbal communication as well. Obviously, we try to have a perfect poker face and to give nothing away, but we're all looking for the read from our opponent, the sense of where they're really reacting and where they're not. And also the practicalities, popping out into the breakout room if you're being led or if you're leading, and having the opportunity just to do some quick shuttle diplomacy is not something that you can do when it's being dealt with remotely. I think also that it brings a sense of focus when everybody's in a room. In the higher value cases, you've always got all of the defendant's team in the room. You may have possibly a reinsurer by phone, but everybody is there and thinking about nothing but the case. Whereas if there's an hour and a half gap in between where they might focus on other work, you lose a sense of occasion, really. A JSM in many ways is almost akin to a trial, and people build up to it and prepare for it, and it comes with its own sense of occasion that I think is beneficial to the process. I agree entirely with what Dan says, though, about having the client remotely in certain circumstances. I can think of a mediation I had post-lockdown where my client was in awful pain for periods of the day, and not having to travel, having a shorter day and the capacity to make himself comfortable with his own adjustable chair in his own environment in a way he knew he could do it was hugely useful. However, it was a mediation where we had a Zoom meeting set up for me, junior, solicitor and clients, but we couldn't then connect properly into the phone mediation. And so that was on loudspeaker into our Zoom meeting. It was very far from ideal.
So perhaps, perhaps then the way forward may be sometimes to give the claimant, particularly if it's a client who has severe pain issues, the option of being at home should they want to, but still have all the lawyers together. It seems maybe a way forward.
I think that's right. The other thing is that when you are conducting it remotely, everything takes longer. When you're shuttling back and forward, it takes minutes to set up. And as a result, we've started to do pre-mediation or pre-JSM conferences in a way that we didn't always. We normally built it up to that day. Actually, I think there is a benefit to that. And in a number of cases, I'll look to keep that in future, I think, to take some of the pressure off and to shorten the day. The point Dan made about fatigue of the more seriously injured clients and the ability to retreat to bed. If you are not requiring them to be there for as long, that's got to be a benefit and something we should be looking at.
One of the downsides, I think, though, is that if you've got a claimant in conference with you physically, as the legal team, you can control what information is being provided and manage that information as best you can. The difficulty when you're dealing with a remote JSM, where a client may be dialing into Zoom meetings every half hour or every hour or so to discuss the latest offer or the latest counter offer that's being proposed, is that you don't necessarily know what's happening during the downtime, and the likelihood is that they are speaking to members of their family, they're speaking to other people who are perhaps less well informed, but still have a view, and that could colour the client's thinking and affect the way in which they react to the advice that you're providing. So, not saying it's wrong, but it's just, it makes the lawyer's job that bit harder.
I agree. Everything takes longer, and if you're having to deal with that sort of point, then it's again, every new meeting you're spending 10 minutes undoing something that somebody else might have said.
Another face-to-face area, Dan, for you will be MDTs. Have you had to have any of those remotely? And if so, how's that been working?
Yeah, we've had quite a lot. Obviously, whenever there's a significant change in the claimant's situation, or a change to the way the care is being provided or therapies are being provided, it often provokes an MDT to see how that's going to be best managed. And so we've had quite a few over the last 6-7 weeks or so. Bizarrely, it's sometimes easier to arrange MDTs when they're being conducted by video link than when they're being conducted in person, because it's easier to get an hour in everyone's diary rather than 3 or 4 hours in everyone's diary when they've got to factor in travel. So we've found that quite helpful. We've also found that it's more likely that defendant representatives attend if they've only got to log into a Zoom meeting for an hour than travel the length and breadth of the country. And I think there's real value in having defendants attending MDTs. I'm not one of those claimant solicitors that seeks to shield my client from defendants, because I think the more that defendants have a proper understanding of, the practical effects of the injury and the difficulties that claimants are facing, the better. We're sometimes spoiled as claimant representatives. We can have as much access to the claimant as we want, and defendants sometimes only see the claimant at a JSM or on the surveillance footage. So I think it does promote collaborative working. And I think it's more difficult for defendants to deny reasonable requests for interim payments or the funding of rehab if they've clapped eyes on the claimant and seen the difficulties they're facing.
And what about geographical spread, Dan? Does that mean you can have clients over a wider range, geographical range more easily?
Yeah, that's right. I mean, certainly at Stewart's we have a London office and Leeds office, but we act for clients all over the country. And so it's easier for us in some respects to do MDTs by way of a video link, if that's the most appropriate way of doing things. The other great advantage, of course, is that, the Zoom meetings can be recorded. So the MDT can itself be sent to the defendants as a video file if necessary, as a very transparent way of letting the defendants know what's going on in almost real time.
And with clinicians, another area where I can certainly see it making sense is, I know I've sat in expert meetings where there's 4 or 5 experts. Usually you may have 1 or 2 in person, but because of restraints with people's diaries, you often have quite a few by the phone as well. I can see that, especially with the way Zoom's set up, where you can have everyone's face on the screen and see what they're doing. And I know, Matt, we'd spoken about this briefly with experts. There may be some advantage to having expert conferences by Zoom.
Definitely. Having rarely used it, I think probably never, or not more than once or twice pre-lockdown for expert conferences, you can't help sometimes suspect that somebody's checking their emails or playing Minesweeper while you're on the phone to them, particularly if it's not a topic that primary focus is on. And this way you can see what's going on, you get better engagement. And so I think from a lawyer's perspective, it's far better. But also, I think it's very much easier for the lay client to be engaged in video. I think it takes a bit of practice to get good at doing things remotely by telephone. And we spend so much time doing it, we perhaps don't always appreciate how difficult it is to focus for an hour and a half, 2 hours of a telephone meeting where you are mainly, you're not even a spectator, are you? You're an auditor, but you are listening and not hearing and not communicating. Whereas if it is visual and you can see who's speaking, I think it's very much easier for a client to follow as well.
Expert evidence is obviously fundamental in a serious injury claim, particularly with relation to care. And I know that some experts have been attempting to carry out remote assessments. I personally can see that that could work in some circumstances. For example, if you've had some of your experts go in already, or somebody's doing an update report. But I do think that this is an area where, especially in serious injury claims, you would struggle. I say that particularly with regard to care experts, because in order to complete a comprehensive report that gets all the detail in that everyone needs, they would have to see the layout of the house, I think, or have some good idea of it. And generally, they would see transfers when they're doing an assessment. So all of that would have to be facilitated, I think, for a care expert to be able to conduct a remote assessment. Do you think that's possible, Dan?
I think it's possible, but I don't think it's preferable. I think we would all, in an ideal world, have our experts see our clients face to face and conduct, if necessary, physical examination of the client. I don't see how a clinical expert certainly could produce a report and be happy with his or her opinion if they've never seen the claimant. It may be possible for them to do a follow-up report, but I don't see how they can produce a report without ever having seen the claimant, because certainly clinical experts are going to be having to put their hands on the claimant to test range of movement, power, sensation, tone, pain, discomfort, the extremes of movement. They're often absolutely crucial to understanding the particular idiosyncrasies of any case. And as you say, in relation to care experts, occupational therapy experts and physio experts, they need to see the claimant's home environment. They need to witness the claimant doing a number of transfers, not just wheelchair to sofa, but bed to wheelchair, to shower chair, into car. And that's not always possible via video link, or it's certainly more difficult via video link. So I do think that there needs to be some face-to-face examination of the claimant. And I think that whereas in the past, we've sometimes had claimants go to experts' consulting rooms to meet with them, I think my preference has always been for experts to go to claimants. And I think that will become the norm going forwards, as claimants who may be in more vulnerable groups are less happy to travel out to city centres, to consulting rooms. We're going to see experts going to them rather than the other way around.
And I think the other point is, and we're going to touch on this in every topic, it's all about preference. So preference of the claimant, firstly. But Matt, what would the situation be if your expert says, I'm not doing it remotely? I know there's been some recent case law about, recording. Is there any difference if an expert says, I don't want to do it remotely, or are they entitled to do that?
I can't imagine any court refusing to accede to an expert's preference in that regard. And if I was the instructing party, if she told me, I want to go and see them, or I want them to come and see me, I would never agree to doing it any other way. I had a case where the claimant was in America, and most of the experts, and neurologists and neuropsychologists, were American experts, which came with its own difficulties. But both parties had instructed English neuropsychiatrists. The claimants had done a video assessment, and our neuropsychiatrist refused. He said, I cannot form a proper opinion in this case unless I meet this lady face to face. So business class tickets and 4 days in Washington, DC was the price we had to pay. But I think in those circumstances, you're either going to have an expert who says, I won't accept instruction, or who caveats his or her report so heavily that it's meaningless. I think you have to go with the preference. It may well be that there's an intermediate step, which particularly if lockdown continues a bit longer, we will see increasingly used, which is I would give a provisional view by remote assessment. And I've also had a case where there's a suggestion that there'd been a change of muscle power after examination, because they were 6 months apart, the claimants and the defendants, and my expert said, well, in that case, I just need to check it. Can we arrange a quick FaceTime on a Monday morning, and I'll tell you what I think. And having already carried out his initial assessment, he was able to say, actually, there has been a change. I wasn't expecting it, but for this and that reason, I agree, and I don't need to see again in person. So there are circumstances in which it can work, and I think our greater familiarity with video is going to encourage us to suggests that. But I can't imagine ever going to trial with having chosen not to have a claimant examined. Getting to a settlement meeting, particularly if you're looking to move things along and shorten the time frame, I can see the benefits to it. And I think we will probably see that a little bit more than we did pre-lockdown.
One thing that's been quite interesting is the defendant approach to obtaining expert evidence since lockdown. There have been some cases where the defendants have said that they need to delay their expert assessments and therefore make amendments to the directions timetable to factor in the longer period of time it's going to take for them to assemble all their evidence. And that's understandable. In other cases, we've seen defendants say, no, we want to crack on and actually we'll get our expert evidence via video link or paper reports, and they're committed to resolving cases within the existing timetable. Obviously, different schools of thought from different defendants, or it may be there are certain factors in those cases which have led to them making that decision. But there does seem to be a split amongst the defendant community about how to deal with these assessments.
That's my experience too, and I think it's going to evolve. I saw in the first week after social distancing, not even lockdown, one defendant making an application for a 6 or 9 month stay, even though their expert evidence was due the week after and they hadn't arranged an appointment. Now, one may say it's opportunistic, but then I'm aware of other insurers for whom I work saying, actually what we need to do, we want to keep things moving, we need to continue to free up reserves, we need to continue to settle cases, and they are taking a slightly more robust approach to the evidence. So either remote assessments or perhaps a slightly broader range of settlement values to be considered in the interest of keeping a case moving.
So in summary, for expert assessments, it seems that they are possible remotely in some circumstances, but it seems that generally they aren't preferable.
I think for claimants who've got to prove their case, the burden's on them. I think the only option for them really is to have at least some point during the case their experts see the claimant face to face. I think for the defendants, they can adopt a more commercial view, and so they've got a number of options available to them.
If experts are conducting meetings remotely and if solicitors are and if counsel are, that's undoubtedly going to have an impact on cost budgeting. Dan, how do you think that's going to be approached?
Whenever there's a significant change to the way we go about performing our roles, parties will look to see if there's any way they can turn that to their advantage, or at the very least to prevent their opponent turning it to their advantage. And one of the ways in which I suspect defendants are going to start to attack claimant budgets is to look at whether the costs involved in the budgets are now justifiable, and clearly the obvious part of any budget there is going to be travel time. I think we're all more accustomed now to dealing with video calls, and we see the value of video calls, and certainly defendants are going to be suggesting that a significant number of the attendances that a solicitor would ordinarily have on the claimant should be done by way of video call, and thus cutting out a lot of travel time. The flip side, of course, is that, as I've already mentioned, I suspect that claimants will want experts coming to visit them rather than them having to go to consulting rooms, and that may have an impact upon the cost of expert reports and so on and so forth. Another interesting issue is that there's been a number of cases where the parties have agreed that it's actually quite difficult to budget for a case for the next 18 months, 2 years, whilst this uncertainty is with us, and have approached the courts by consent saying, can we defer the issue of budgeting until there's greater clarity? And in some cases, the courts have acceded to that request. In other cases, they haven't. So there is the possibility that some courts will defer the question of budgeting for another day. The other area where I think budgets will be affected is in relation to the cost of trial. Matt, you'll have a greater understanding of this, but certainly my impression so forth in relation to the hearings that we've undertaken by Zoom or Skype is that hearings just tend to take a bit longer. And so what might have been a 4-day trial might be a 5-day trial, and so on and so forth.
Yeah, I think that's undoubtedly right. Somewhere between 20 and 40% longer, depending on the volume and complexity of the evidence with which you're dealing, to allow for the technical dropouts, to allow for the need for everybody to be assembled remotely, and for the judge to become involved. If there is a requirement to take somebody to video, for instance, or to look at documents in detail, then unless it is conducted by people very familiar with using the technology, it adds a huge amount of time. It's also very tiring. Sitting in front of a screen all day is something we're used to doing for an hour at a time and a cup of coffee. But if you're doing a 2.5 hour court session with no break, and that is the totality of your focus, it's really rather draining. And I think we will probably end up building in time for parties to have a short break, just as we do in jury trials, so that the 2.5, 3 hour session is not too long. So I suspect there is little saving to be made. If anything, there is an expense incurred in trials taking place remotely. Whether, though, some expert disciplines or some witnesses who are speaking only to a short issue will be dealt with remotely is a different matter. The difficulty currently is often it's hard to ensure the court has sufficient equipment. I would hope that one of the things that comes out of this is a realisation that they need to invest in this, because there are savings in judicial time, in court time, in parties' time to be made if it is almost standard for a witness who's there for 10 or 15 minutes, but is important nevertheless to be slotted in remotely rather than travelling for 2.5 hours, hanging around for half a day and then disappearing. In terms of the budgeting, one of the local cost judges is a big fan of recording assumptions. And so, we are budgeting on the basis that we assume there will be this, that and the other carried out remotely and in person for this, that and the other, because if that proves impractical, then at least you have a good reason to depart. Because at the moment, we have no experience really of what our costs are looking like overall, because we've been going a month and a half. In 18 months, we'll all be old hands at it and we'll know how it's impacted. But at the moment, we're looking ahead and crystal ball gazing.
The fourth topic that we were going to consider is how it's having an impact on claims that are ongoing at the moment. And Dan, I imagine one of the things that you're having to consider as a solicitor is the care regimes that are in place, and have they been impacted at all?
Yeah, they have, particularly for our spinal cord injury clients who, as you'll understand, are more prone to respiratory difficulties than the general population. So they're having to be especially careful and take precautions to prevent them acquiring this virus. One of the things we've seen is that to reduce footfall in and out of their property with their care teams, that some claimants have moved to a living care model. So they've got the same carer with them for a whole week at a time, rather than a team of 4 or 5 coming and going on a shift system. And in some cases, that's increased the cost of their care package, certainly temporarily. And depending on how long we may have to live with this virus as being the new norm, it could affect their care package and the cost of providing that into the long term as well. So that's been a very real knock-on effect for some claimants. Another issue that's certainly at the forefront of my mind is which case manager that we use for each client. Historically, we've very much thought about case managers in terms of geography. So we've got a client in East Anglia, we need to find a local case manager, a client in Yorkshire, find a good case manager there. As case managers are getting used to dealing with things at arm's length, managing the care package, coordinating the rehab via video, via email, etc., geography becomes less of an issue. And so you can select who you think is the best case manager for that particular client, irrespective of where that client might live and where the case manager might be based. That's one potential positive going forward as well. And in terms of the cost of the case management, the likelihood is that case management costs will probably decrease because of the reduced amount of travel time that the case manager will be charging for. So again, a potential windfall for defendants there.
Although I expect if there's issues with carers at the moment and they're having to change care arrangements, that might increase the amount of time case managers are actually having to spend working on the case. So perhaps it'll be a case of levelling more than anything.
Yeah, I think that's right. I think whenever there's a change in the claimant's circumstances, when they move to a new property, when there's a change in a care regime, there seems to be a spike in case management input. I think that's absolutely right. But I think that will probably be a short-term increase in terms of looking at the medium-term, long-term costs. Certainly the lifetime cost for a claimant, the cost might decrease.
And there's also been, hasn't there, because of this, a learning curve for everybody. It was happening in the statutory services as well as in care regimes in personal injury claims. you had the need to control infection, and so people running children's homes were having to stay living in if there was an infection and so forth. Once you've seen how to adjust it once, it's a learning curve you don't have to replicate. And so whilst there would have been a huge spike, and I'm sure in March and April, for case management costs, if we have a second spike in infection, which clearly we all hope we won't, we're not going to see precisely the same thing repeated, I suspect.
One of the interesting aspects in relation to care claims is that ordinarily we're used to seeing an allowance of live-in care for X weeks per year, when a claimant is unwell. And I just wonder whether care experts will start to recommend an increased allowance of live-in care for periods where there are lockdowns, if we are going to undergo, lockdowns frequently over the course of the next few years.
I think that's inevitable. And I think it's going to impact on other elements of a care and support regime, the therapeutic regime, isn't it? If we're looking at provision of physiotherapy, of hydrotherapy and so forth, there are always arguments about how much of it needs to be in-home domiciliary provision and how much of it is travelled for. I suspect the balance is going to shift very slightly in terms of what is likely to be in-home.
I agree, and I think hydrotherapy is generally an area which is disputed between claimant and defendants anyway. And I think what's important here is there's no end line at the moment, no end date of COVID. The lockdown will be lifted, but that won't be because COVID doesn't exist anymore. It will just be that the rate of infection is lower. And I know, Dan, you touched on earlier that spinal injured claimants in particular have vulnerability to respiratory issues. And I can understand that for that, this is an area that's going to bolster the argument for hydrotherapy pools or hot tubs in the home, because hydrotherapy pools are often quite a distance from a claimant's home anyway. There's already an increased risk of infection, and shared space just isn't going to be preferential at all when we're considering risk to people who are already vulnerable.
Yeah, and obviously the higher someone's lesion, the more vulnerable they're likely to be. So if you've got tetraplegic clients, they are going to be exceptionally vulnerable, and they may well be very reluctant to go to shared spaces like hydrotherapy pools, like gyms and other places, and may prefer to have those facilities at home. And so, it remains to be seen how long we'll have to live with this and whether a vaccine is available. But in the event that it isn't, and the best scientific evidence is that we'll be living with this on and off for a while, then it may bolster those sorts of cases.
And so that's going to impact, isn't it, on the nature of the accommodation claims in terms of what's allowed, exercise space, therapeutic rooms, potentially even an additional bedroom in case a household member has to self-isolate. That becomes far more important than it was pre-lockdown or pre-infection.
And accommodation is a very real problem facing claimants at the moment. It's often when claimants are in hospital, it's often the biggest issue that they're playing over and over in their minds again. Where am I going to go? I can't go back to where I lived before. Where am I going to go? Where are my family going to live? And one of the difficulties at the moment is that the amount of accommodation that's available on the market, whether to buy or to rent, has decreased significantly. People aren't putting their houses on the market. They're reluctant to move themselves because they don't know what their own financial circumstances will be. People who are renting properties aren't giving up leases because they're locked down at the moment. So why would they contemplate moving somewhere else? The housing stock isn't great at the moment. And that presents a real practical difficulty for claimants. I was, looking at potential properties for one of my amputee clients just yesterday. And whereas 3-4 months ago, there were a lot of potential properties on the market, there's very little available for him now. So on a very practical day-to-day basis, it's causing problems for claimants.
And this is a problem that's going to be particularly acute until we get an understanding of how far and how quickly we're coming out of this. We're looking at predictions for the economy, which is clearly going to impact on the value of accommodation claims, the value of property. Because if you've got a case going to trial in June to October, what are you going to do about valuations as they stand? Nobody's going to accept them as being still and reliable, but they might very quickly become so again if it's March next year, mightn't they?
Because the purchase of a property and the adaptation of that property is usually the single largest capital item in any schedule, I tend to prefer my clients to have at least identified a property that they're going to buy and have a feasibility report on the cost of the extension works before the claim is concluded. So we're working from actual numbers rather than purely hypothetical numbers. But I do foresee that there'll be more cases concluded on the basis of hypothetical properties than actual properties. And clearly that places the risk with the claimant then, that if the property they end up buying costs more money or the adaptations cost more money, that they will be feeling the effect of that.
And subject to SWIFT, which we know is one of the few things definitely going ahead remotely, we're told. It's the adaptation cost, which is the greatest variable. Because as you say, if there's some unforeseen eventuality in a property that's purchased, something slightly outside the standard, whether it's landscaping or so forth, that rapidly adds up to a significant increase, doesn't it?
And in a similar fashion, when you consider holiday claims at the moment, there's clearly no international travel that's going to be anticipated this year. I don't know what the pitch is going to be next year, but surely there's going to be an impact on that as well. And certainly from a defendant's point of view, if you were to see a claim pleaded with international travel every year for the next 5 years, for example, I think it's certainly a question of how feasible that would be in any event.
Yeah, I think holiday claims are one of the most underpleaded heads of loss in a lot of schedules. I don't think that a lot of claimant solicitors have really got their heads around what the actual increased cost is for a lot of people with significant disabilities in terms of the cost of the flights, the cost of the additional accommodation, the cost of equipment that might need to be hired out where they're going, the cost of transport out there, the cost of taking their carers with them. The costs are actually very significant and often underpleaded. So they do constitute pretty significant chunks of a schedule. But you're right, if the likelihood of international travel is significantly reduced over the next year, 2 years, 3 years, 5 years, then a lot of the arguments underpinning those holiday claims fall away. So it'd be interesting to see how the courts grapple with that. Maybe they allow a contingency for the next few years and then back to normal thereafter. But it'd be interesting to see.
But you just raised one of the points: hired equipment. If you are travelling to somewhere maybe that's not traditional destination, not first world, and where some of the more bog standard holiday sickness claims eventuate, if you are a vulnerable claimant, you're going to be really worried about hiring equipment that would have been used elsewhere. Are we looking at adding the cost of transporting your own necessary equipment to a holiday claim rather than hiring it? I'm glad somebody else is going to be doing the numbers on that, not me.
Yeah, I don't know the cost of transporting a profiling bed via business class is, but I suspect it's quite significant.
I suspect so.
But in any event, we don't know that travel's not going to increase the cost generally, especially if we're going to have social distancing, because if measures are going to have to be implemented on planes, for example, then I would think that the cost would go up because there's less footfall. The discount rate has already been talked about for quite a few years, and it's next set to be reviewed in 2024. We've seen already in the news the impact on our economy that this is going to have. Dan, how do you think this is going to impact the discount rate into 2024?
Well, it's difficult to know what's going to happen over the next 4 years, but certainly there's been a lot of market turmoil so far, and we're by no means out of the woods yet. So the other issue, of course, is that with COVID-19, the defendants are likely, I suspect, to start factoring that into their thinking on life expectancy, certainly in relation to spinal cord injury cases, where, as I've already mentioned, claimants have a particular vulnerability. We've already seen it argued in certainly 2 cases that I'm aware that some years should be knocked off the life expectancy given by experts who reported pre-COVID-19. So the combination of uncertainty in the markets and defendants arguing that life expectancies are reduced, I think, makes periodical payments all the more attractive for claimants. And I think we're going to see more claimants opting for PPs, certainly for care and case management and potentially for other heads of loss.
Dan, I think that's a really good point. The tension for a defendant between succeeding too highly on life expectancy arguments and pushing a claimant more strongly to accept PPs is a difficult tightrope for them to walk. I wonder, particularly in the next year or two before we have big data, what approach is going to be taken to life expectancy arguments around COVID and similar respiratory infections, because generally the courts, the masters, are steering away from allowing statistical evidence in addition to an assessment from a neurologist. But it seems to me it's more likely to increase now, isn't it?
Yeah, the likelihood of them getting a standalone expert to deal with life expectancy issues, the Strausses of this world, has probably increased. But as you say, it's difficult for them to provide any sort of opinion at the moment because the data is not available. We're only, 8 weeks into this in the UK, and only, 5 months into it globally, really.
Yeah.
So to conclude, it's clear that COVID-19 has had a significant impact upon the way we conduct catastrophic injury litigation. Some of the changes we've been forced into actually appear to be fairly positive and will probably be part of our practice going forward. Other elements are less favourable, and we'll hope to see the back of them. As this crisis continues, we will learn more and adapt our practices and see how we can best serve the needs of our clients going forward.
Dan, one thing I'm desperate to get back to is having my hair cut. Are you going to stick with clippers?
Yeah, I've been forced to go down the clipper route, and I can't see me going back to a more conventional hairstyle now. It's so much easier.
You two are like the two approaches to lockdown. Dan, you've gone with all the hair off, and Matt, you've just got all of the hair.
Good. Well, Lois, thank you ever so much for organising this, and Dan, thanks for joining us and for your insights, and look forward to talking to you again soon.
Thank you. Bye.
Bye.